episodes of Cops.
I'm going home. You're going to jail.
Cops, tonight starting at 8 on Court TV.
We are on verdict watch at the Cody Posey murder trial. So what was going through Cody's mind the morning that he shot his family to death? Here's what he told the jury.
I lost control, sir. I didn't know what I was thinking. I didn't know what I was doing. I don't know what I was thinking. I couldn't tell you. I myself wish I knew what I was thinking. I more or less lost my mind, sir.
So did Cody Posey help or hurt his case by taking the stand? Joining us now, Gary Mitchell, Cody Posey's defense attorney. Terrific to speak to you, Gary. Thank you so much for joining us.
My pleasure.
In your opening statement, we heard about an extreme emotional disturbance. In Cody Posey's testimony, which we just saw, he says, quote, "I lost my mind, more or less." Well, you couldn't argue that in closing argument because the judge took away from you a diminished capacity defense or an extreme emotional disturbance, Cody just snapped kind of defense. So you were left with self-defense. Would you agree that what you were left to argue in closing is a little bit different than what you opened with?
Well, a little bit, but not very much. I mean, we'd always thought that this was a self-defense case, and the diminished capacity issue was an issue that we had to raise simply because we felt that certainly his capacity had been diminished. But New Mexico is pretty bizarre when it comes to any type of insanity or diminished capacity defenses because they require so much to show that. And it's a hard burden to meet on behalf of the defense.
If you had it to do over again, though, knowing how the judge's ruling was going to turn out just before closings, would you have had Cody on the stand say, "I shot them because I was in imminent fear for my life and I had to defend myself"?
Well, Cody said what he said, and we didn't prep him for that. I asked him, and he said I said, "I want you to tell me what you were thinking at the time, and I want you to be honest about it," and that's what he said. So we lived with that, and no, I don't think I would have changed it having Cody testify. I thought he was our best witness. I thought the jury needed to hear from him, and I still think that to this day. I don't have any second thoughts about it.
Well, let me bring in our jury consultant, Carolyn Robbins-Manley. Cody on the stand did get good reviews for the most part. He was polite, he was respectful, he was straightforward, but not emotional. And what about this bit of a disconnect now that he said he lost his mind more or less and the defense is left arguing self-defense?
Well, I think the jurors are going to focus on that. I think we heard that they did ask during deliberation to see the video of his testimony again. I think it's really more of the focus, in my opinion, is going to be on whether they are comfortable having him go to the federal penitentiary as opposed to stay in the juvenile system. I realize that sounds like they might back into the verdict. They may discuss it. They may not discuss it as much as they think that. But I really think that we have to address that issue. With respect to the father, I think it's much easier to come to the manslaughter verdict or the self-defense acquittal verdict. But when you go down the list and you get to the stepmother and then the stepsister, you know, that's where it becomes a much harder decision.
And Gary, you know, the jury did ask for the DVD player. That's all they've asked for. There's only one DVD for them to look at, if I'm not mistaken. That's Cody Posey's videotaped police confession. That was played by the prosecutors at the end of their rebuttal. Did that make you a little bit nervous? That's what they've asked for?
I thought that was a wise move on behalf of the prosecution. You know, it was a good trial move by them, and I applaud them for it. There were parts that if they watch the whole thing and take the whole thing in consideration, I feel very comfortable with what Cody had said at that interrogation, and that the jury will be able to see into what was really going on at that interrogation. You know, the officer walks out a couple of times and goes and talks to the prosecutors and gets guidance from them as to the appropriate questions to ask. It's basically a 14-year-old child dealing with two investigators and two experienced attorneys.
You know, Gary, we're not used to attorneys like you here on Court TV. You're unflappable, and you don't badmouth anybody involved in the case. You really have a certain professionalism about you, and I have to say it is refreshing. Lisa Pinto, let me bring you in, though, from the prosecution point of view. What about this change in the defense case from diminished capacity, Cody snapped, to, well, he did it to defend himself?
Well, at least what I'm struck by, and I'm not going to be so friendly here, is the fact that his client, Mr. Mitchell's client, was all about how he shot the stepmother because she was near the telephone and he didn't want her to call call 911, and then he was talking to the cops about how he shot his sister so she wouldn't go tell or nothing. So the Cody, the poised, I'm crazy on the stand Cody versus the Cody that, you know, was seen right after the crime. I'd like the jury to compare and contrast those two when they reach a verdict.
Well, what about that, Gary? He did say in his police statement that he killed Mayor Lee because he didn't want to witness.
Well, that didn't concern me as much as what led up to this entire matter, because to me, we missed the point when we start talking about the actual event and what occurred at the actual event, because I don't think most people with common sense think that the child was thinking about anything at the time. And you know, we have to look at what he was trying to do, which was to preserve and protect himself. And we may not like the way somebody defends themselves or the weapons they use to defend themselves, but the fact of the matter is they had that right.
Gary, you know, you are remarkable because you managed to shift the focus away from the central issue in the case, which is, of course, the killings. And not only that, not only are you doing that here on this program, but in the courtroom, you were able to prevent the prosecutor on cross-examination of Cody Posey from asking about the shootings themselves. I got to tell you, I was flabbergasted. How the heck did you do that, Gary?
Well, I appreciate lawyers and people that spotted that. We just simply didn't ask him about it, and then we objected as it being beyond the scope of direct, and obviously the defendant and a child in this case is entitled to certain protections under the law, and I said, Judge, it's simply, we didn't get into it, they can't get into it.
Beyond the scope of direct, all right, Joe, beyond the scope of direct, he asked about what was in Cody's mind. We just saw the clip of Cody saying, I lost my mind, and that's why I did it. Have you ever had a homicide case where the prosecutor can't ask the defendant on the stands about the shootings?
No, I mean, that's, look, God bless Gary, he got a great ruling. I've never had a judge, nor will I ever have a judge, I'm sure, that will preclude me from putting my client on the stand who's charged with murders and not have the prosecutor be able to ask him about the murders.
Right.
I mean, there's a whole host of reasons why that's permissible cross. This judge obviously decided to protect the witness, which is, I'm all for protecting the witness, especially if the witness is my client. But, you know, one thing that we have to say here, the focus should not have been, and I agree with Gary, the focus should not have been on the event. The focus should have been on the state of mind. And this jury is grappling clearly. Look, if the focus is on the event, the verdict would have been in about 3.5 minutes. And you know, I see Lisa moving and shifting here. I feel like I need equipment when I'm sitting next to Lisa. But you know,
some murder here, Joe. Everybody
what is that issue is his state of mind and what he was thinking leading up to that point. Because clearly, if it were as simple as the event, we'd be out of here by now.
All right, and there was one triggering event, according to Cody Posey. Take a listen to this.
In front of the bed, Treon pulled down the covers, and she was laying there completely naked. My dad striked up the torch and told me that I was going to have sex with Treon. I refused to do it, told him I wasn't going to do it. And as I was telling him I wasn't going to do it, he was heating up this rod. It doesn't take that long to get it pretty hot. He walked up to me and burned me and they were fairly good-sized burns at the time.
Dean Johnson, that is an event that Cody testified to that I think is so shocking, it could have caused nearly anybody to snap. And here we're talking about a 14-year-old. Problem is, Cody snapping is not an issue that the jury can consider anymore. So how do we work out self-defense of a sexual abuse that wasn't life-threatening into an acquittal for Cody Posey? Does that make any sense?
Well, it really doesn't. As far as I know, I just snapped has not yet been recognized in the law as a defense. Now, let's assume, which the prosecution apparently does not, that this event actually happened. If at the time of the event, Cody had turned around to his father as he was heating up the blowtorch and done something to him then that resulted in his death, probably a classic case of voluntary manslaughter at best. But what we have here is not that. We have a long cooling off period leading up to the next day where Cody is not in a fear of imminent bodily harm, where he is very carefully calculating what he's going to do, where he not only takes away the source of the abuse, which can give him possibly imperfect self-defense, but also takes out collateral witnesses. That's a very tough row for the jury to hoe to get to an acquittal. And
Gary Mitchell, when you put Cody Posey on the stand, did you consider having him express some remorse?
No, not really, because I think jurors see through that kind of action by attorneys.
Not if it's sincere.
They appreciate the, well, you know, it's not the time nor the place for it at that point, I felt, and and I felt the juries think that that's something the attorneys set up, and a lot of what I do when I try cases is try to gain the confidence of the jury, that they know that, well, at least with Gary, you're going to get an honest recitation of the events, and he's going to appear in front of you, and you can trust what he's doing and what he's saying and how he's feeling. And I think that's an integral part of a good defense attorney. You know, this whole business about in the heat of the moment and whether or not it occurred within a certain period of time. I think you have to remember that for children that are being abused, the danger never leaves. The danger is always imminent for them.
Yeah. All right, Gary Mitchell, thank you so much for joining us. And stand by, panel. We've got much more ahead as Verdict Watch continues here on Catherine Crier Live. But first, check out tonight's bullet points. Marriage can be viewed as a contract between two people, but the guy you see here took his wedding vows, well, a little too literally. He created something called the Contract of Wifely Expectations, which stated his spouse had to obey his specific demands, including requirements about hygiene and sex. If she followed the rules, she even earned points for good behavior. What a guy! Of course, the wife says she never signed any such agreement. The husband now faces abuse charges and could soon enter into a new agreement. It's called a jail sentence. We'll be right back.